The false virtue of silence. Most people in family law, be they judges, lawyers, guardians ad litem, or others, love to recite the same comforting mantra. We protect the children by keeping them out of the litigation process. It sounds noble. It's also wrong. We built an entire culture in custody litigation in Utah around the idea that the way to protect a child is to refuse to hear from the child. Courts act as though a child's voice is too fragile to be heard, that too dangerous to allow the child to testify, too sacred to touch. But here's the problem. The child is one of the most percipient witnesses, if not the most percipient witness, in the child custody and parent time case. Children know who helps with homework, who loses their temper, and why, which home is stable, and what their lives are actually like in each parent's home and generally. Yet we silence the children, not because evidence shows testimony harms them, it doesn't, but because the system seeks to avoid complexity and discomfort around child testimony. We've convinced ourselves that asking a child questions for the record equals trauma without any data to support it. A respectful, structured interview isn't abuse. Pretending trauma is inherent is just lazy thinking disguised as compassion. Judges already have tools to protect children, Rule 403 and Rule 611 of the Utah Rules of Civil Procedure, with in-camera interviews, recorded statements. Nothing requires banning testimony altogether, and who pays the price? Children who are misrepresented or not represented at all, whose lives are decided by adults who have never spoken to them, and whose fate rests on hearsay from people who cannot be cross-examined and held accountable. Cross-examination itself gets caricatured as some hostile, melodramatic grilling, but skilled lawyers routinely question vulnerable adults and minors gently and productively. We can question a child sensitively and appropriately in a custody case. Silencing children doesn't protect them, it shields the adults from the truth. If we're serious about a child's best interest, courts must stop congratulating themselves for refusing to hear the one witness who knows the most and who has the most at stake in the child custody and parent time decisions of the court. Do you really want to act for and in the best interest of the child? Then let the child speak, on and for the record.